there would be a shortage of judges to adjudicate over many disputes. Litigants generally win some and lose some. Should they call for the recusal of the judges before whom they have lost cases in the past? Additionally, the applicant, if he had any discomfort with my presiding over this current matter based on that case, ought to have acted and moved the recusal application prior to the arguments. He did not and has not explained why in these current proceedings, he did not and has not explained why in these current proceedings, save attempting to do so in his replying affidavit. I reject to allow such averments which were known to him, yet he failed to foreshadow them in his founding affidavit. He has thus failed to satisfy all the tests of recusal. On recusal, no reasonable person aware of the Zodilo matter, its facts, the evidence, and the decision imposed by the court will apprehend any reasonable bias against me in presiding over the present matter. Lastly, on the CMB matter, the applicant has simply made bold and unsubstantiated allegations once again and has not sought to state the relevance of this case to these proceedings. He was not a party therein. It was his informer, Mr. Waikile, who has prompted the applicant to seek to use this matter to seek my recusal, who was involved in that matter and not the applicant. Applicant contends that he is informed that CMB, which was then under liquidation, had received laundered money from the POPF. It is not clear how a reasonable person could apprehend reasonable bias insofar as this matter is concerned. It is apparent that this application is totally unmerited, a red herring, an abuse of the court and its processes, for were it legitimate, the applicant would have moved it prior to the arguments in the main application, as all the things he complains about, save for one matter, were in his know all along. To act in the manner he has, without proper or reasonable justification, smacks of malice and unreasonableness, and it is an attempt at plain delaying tactics on his part. I have been called upon by the respondents to award costs against the applicant on a punitive scale, and considering everything that I have dealt with above, this matter is one where a punitive order for costs is absolutely justified. I therefore proceed to make the following order. A, the application for my recusal is unmerited, an abuse of this court, and is thus dismissed. B, the applicant is ordered to pay costs of this application on attorney and own client scale in favor of the respondents. This is my judgment, my ruling. There is one or two corrections, so bear with us. We'll have to make those corrections before the ruling is given to the parties, but it will take a short while. There is the ruling or judgment in respect of the main application, which will be delivered in the next 15 to 20 minutes, as I had indicated in my order yesterday. The court will adjourn.